31 Practice Questions, UBC Real Estate Chapter 4. The subdivision of land and title registration in British Columbia.
Question 1. Which of the following correctly describes the nature of the ownership in land that is held by the owner of a strata lot in a freehold strata development? The correct answer is D. A fee simple interest in the strata lot and a proportionate fee simple interest in the common property as a tenant in common with the other owners. Explanation. In a freehold strata, owners have a fee simple interest in their strata lot, full ownership of their unit. A proportionate fee simple interest in the common property as tenants in common, shared ownership based on unit entitlement. This structure ensures collective ownership of shared spaces like hallways and parking areas. Andrew forged a mortgage and registered it against the fee simple title of Julia without her knowledge. Andrew then went to the handy-dandy finance company and sold the mortgage to them. Wendy, an employee of Handy Dandy, searched the title and ascertained that Andrew was the registered mortgagee prior to buying the mortgage from Andrew. Subsequently, Julia learned of the mortgage when Handy Dandy sent notice to her instructing her to make her payments in the future to Handy Dandy. Julia told Handy Dandy that she had never granted a mortgage to anyone and that she had no intention of paying them anything. Andrew is now living happily in Bolivia. Which of the following statements is true? The correct answer is C. Handy Dandy will not be able to recover the mortgage debt from Julia, but they will be able to recover the amount of the mortgage from the assurance fund. Explanation. Handy Dandy relied on the Land Title Act when purchasing the mortgage from Andrew, the registered mortgagee. However, since the mortgage was fraudulently forged, Julia is not liable to repay it, as she never granted the mortgage. Under the Land Title Act, Handy Dandy can recover their financial loss from the assurance fund, which compensates innocent parties affected by fraud in the land title system. Julia can have the fraudulent mortgage removed from her title. Question 3. In relation to the notation of a trust on the title for a property, which of the following correctly describes the meaning of a trustee? The correct answer is A. The trustee is the individual or entity in whose name the trust property is held. Explanation. A trustee is the individual or entity in whose name the trust property is legally held. The trustee manages the property on behalf of the beneficiary who holds the beneficial interest. Options B, C, and D describe roles that do not align with the legal definition of a trustee in the context of property trusts. Question 4. Which of the following options best describes a caveat? The correct answer is D. A registration against the title to land made at the request of a person who claims an interest in the land. Explanation. A caveat is a registration against the title to land made at the request of a person who claims an interest in the land. It serves as a warning to others that the land is subject to a potential claim or interest. Option A. Incorrect. A caveat is unrelated to warnings from the prosecutor's office. Option B. Incorrect. A caveat is not a notice of a court action but may be related to a claim of interest. Option C. Incorrect. A builder's lien is a separate legal mechanism, not a caveat. Question 5. Which of the following is not an exception to the principle of indefeasibility under the British Columbia Torrens system of land registration? Correct answer, C. A registered fee simple acquired bona fide for value without knowledge of an earlier fraudulent dealing in the fee simple title. Explanation. Under the British Columbia Torrens system of land registration, indefeasibility means that the title as it appears in the land title register is conclusive evidence of ownership, subject to a few exceptions. These exceptions include a lien for unpaid provincial taxes. These are statutory charges that take priority and are exceptions to indefeasibility. A public right-of-way in favor of BC Hydro and Power Authority. Public rights or easements are recognized exceptions. A right of expropriation under a BC statute. Government authorities can expropriate land under statutory authority, making it an exception to indefeasibility. However, a registered fee simple acquired bona fide for value without knowledge of an earlier fraudulent dealing is protected under the principle of indefeasibility. This means the bona fide purchaser's title cannot be challenged based on earlier fraudulent dealings. This is not an exception, but rather an application of the principle. Question 6. Luke and Alan are co-owners of a property as tenants in common. They signed an agreement that stated that if either party wanted to sell their interest, the other party would have a right of first refusal to purchase the other party's interest. Alan discovers that Luke has entered into a contract to sell his interest without offering Alan an opportunity to purchase the property as previously agreed. What should Alan do at this time? Correct answer, B. Alan should register a caveat on the property. Explanation. A caveat is a formal notice registered against the title to land that prevents any further dealings with the property until the caveat is resolved. In this case, Alan should register a caveat to protect his right of first refusal, as agreed with Luke, and to prevent the transfer of Luke's interest to a third party without honoring the agreement. Option A, filing a certificate of pending litigation, CPL, is not appropriate unless a lawsuit is already commenced. Option C, a judgment can only be registered after obtaining a court judgment, which has not occurred here. Option D, hiring a bailiff to take possession is not a legal or valid option in this situation. By registering a caveat, Alan ensures that the property title reflects his claim until the matter is resolved. Question 7. Which of the following statements about bare land strata developments is true? Correct answer. D. The owners of bare land strata lots will be responsible for the costs associated with the common property of the development, which may include outdoor recreational facilities such as lakes or trails. Explanation. In a bare land strata development, lot owners share ownership of the common property, e.g. roads, trails, recreational facilities, and cover maintenance costs through strata fees. Uniformity is enforced via restrictive covenants, not easements. Roads are typically maintained by the strata, not the municipality. C. Bare land strata developments can include non-residential uses like commercial properties. Question 8. Which of the following statements is true pertaining to the purposes of assessment and taxation? The correct answer is C. Explanation. In a strata development, the property is assessed as a whole, but the taxes each owner pays are based on their unit entitlement. Unit entitlement represents the proportionate interest each strata lot has in the common property, which determines how much tax they are liable for. A is incorrect because the strata development is not assessed as a whole in terms of destruction value. B is incorrect because common areas are part of the strata's overall assessment and are not separately taxed. D is incorrect because the common property and individual strata lots are not treated as separate parcels for tax purposes. Question 9. Which of the following statements about the principle of indefeasibility is true? The correct answer is C. In British Columbia, there are a number of exceptions to the principle of indefeasibility. Explanation. A is incorrect because both legal and equitable mortgages are subject to the principle of indefeasibility under the Torrens system, as long as they are properly registered. B is incorrect because the principle of indefeasibility applies to the registered title holder, not just a buyer dealing with a registered charge holder. C is true because there are exceptions to the principle of indefeasibility in British Columbia, such as fraud or a prior registered lien, e.g., unpaid taxes. D is incorrect because the principle of indefeasibility is more aligned with ensuring the certainty of title rather than the common law doctrine of void deeds. Question 10. Jacob hires Choo Choo Contracting, Choo Choo, a general contractor, to renovate his living room to better display his model train collection. Choo Choo subcontracts Jennifer, an electrician, to install the specialized electrical connections. After Jennifer completes the work, but before she has been paid, Choo Choo suddenly goes out of business. Which of the following statements is true? The correct answer is A. Jennifer can file a builder's lien against Jacob's property by submitting a claim of lien to the Land Title Office within the lien filing period. Explanation. A is correct because Jennifer, a subcontractor, can file a builder's lien within the lien filing period, typically 45 days, if she's not paid. B is incorrect because a lien affects the new owner if the property is sold before the lien is filed. C is incorrect because subcontractors can file liens even if they were not hired directly by the property owner. D is incorrect because a certificate of pending litigation must be filed within 45 days to enforce the lien, not 21 months. Question 11. Under the Torrens system of land registration in British Columbia, if property is registered in favor of a trustee, this is shown by which of the following? The correct answer is C. A notation of trust on the title. Explanation. C is correct because under the Torrens system, if property is registered in favor of a trustee, a notation of the trust is placed on the title. A is incorrect because a caveat is a notice to protect an interest but does not specifically indicate a trust. B is incorrect because a lis pendens is used to notify of pending litigation, not to show a trust. D is incorrect because a trustee does not receive a duplicate certificate of title unless they are the registered owner, and this alone doesn't indicate a trust. Question 12. In order for a person to make a successful claim against the Assurance Fund in British Columbia, they must prove three of the following. Indicate the exception. The correct answer is C. The person who deprived the injured party of their interest or estate in land has resold the interest to a bona fide purchaser for valuable consideration. Explanation. A is correct because the person must have lost an interest or estate in land to claim against the Assurance Fund. B is correct because the claimant must prove they cannot recover their interest through court action. D is correct because the claimant must show that without the Land Title Act, they could have recovered their interest in land through a court action. C is the exception because reselling the interest to a bona fide purchaser is not a requirement to make a successful claim against the Assurance Fund. Question 13. A fee simple owner in British Columbia who is the victim of a fraudulent conveyance of their land will lose the right to have the transfer set aside when? The correct answer is B. The title to the property has been transferred to a good faith purchaser for valuable consideration. Explanation. A is incorrect because simply registering the transfer does not prevent the victim from seeking to set aside the transfer if fraud is proven. B is correct because under the Torrens system, if the title is transferred to a bona fide purchaser, one who bought the property in good faith and for valuable consideration, the victim may lose the right to have the transfer set aside. C is incorrect because a criminal conviction for fraud does not automatically affect the registered title under the Torrens system. D is incorrect because notifying the registrar does not automatically prevent the fraudulent transfer from standing if the property has already been transferred to a bona fide purchaser. Question 14. For purposes of assessment and taxation, the correct answer is B. Each strata lot, together with the owner's share in the common property, is deemed to be a separate parcel of land and improvements. Explanation. For assessment and taxation purposes, each strata lot is assessed individually, along with the owner's proportionate share of the common property. This combined interest is treated as a separate parcel of land and improvements for the purpose of taxation. This ensures that each owner is taxed according to their share of both the strata lot and the common property.
Question 15. In British Columbia, before approving a conversion of a rental building to a condominium, the approving authority must consider a number of factors. Which one of the following is not a mandatory consideration? The correct answer is D. The potential increase in real property tax revenue. Explanation. When approving a conversion of a rental building to a condominium, the approving authority must consider factors such as the priority of rental accommodation, the proposal to relocate tenants, and the life expectancy of the building. However, the potential increase in real property tax revenue is not a mandatory consideration in the approval process. Question 16. Which of the following statements about duplicate certificates of title is true? The correct answer is B. Certain documents, including easements and builder's liens, cannot be registered if a duplicate certificate of title has been taken out of the Land Title Office. Explanation. If a duplicate certificate of title is issued, certain documents like easements or builder's liens cannot be registered against the property until the duplicate certificate is returned to the Land Title Office. This prevents the property from being transferred or encumbered without the certificate. A. False. A duplicate certificate of title can be issued even if there's a mortgage. False. A duplicate title isn't automatically issued upon transfer. It's only issued on request. D. False. Depositing a duplicate title doesn't fully prevent property conveyance. A mortgage is a more secure option for lenders. Question 17. Which of the following statements concerning the common law doctrine of the void deed is true? Correct answer, C. A deed given in exchange for illegal consideration is not a void deed. Explanation. A deed exchanged for illegal consideration, e.g., a transaction involving fraud or unlawful activity, does not automatically make the deed void. While such a deed may be challenged in court, it doesn't inherently make the deed void under the common law doctrine of void deeds. The issue of illegal consideration is usually resolved in the context of contract law, not void deeds. A. False. A current owner under a void deed may still seek remedies through the legal system, not just compensation from the government. B. False. A void deed does not automatically invalidate all subsequent transfers made in good faith and for value. Subsequent transfers may be valid under the principle of indefeasibility. D. False. A current owner under a void deed can achieve certainty of title after 25 years through adverse possession, provided certain conditions are met. Question 18. Which of the following is a valid mandatory component of the strata plan that a developer must deposit at the Land Title Office to create a strata development? Correct answer, B. The area of each strata lot indicated in square meters is a mandatory component of the strata plan. Explanation. The strata plan must show the area of each strata lot in square meters. This is required to clearly define the size of each individual unit within the development. A. False. The street address is not a required part of the strata plan. C. False. Standard rules for the strata corporation are not required to be included in the strata plan. D. False. The telephone number for the strata corporation is not a mandatory part of the strata plan. Question 19. Sections 15 and 18(1) of the Manufactured Home Act provide that no person shall move a manufactured home unless, the correct answer is B, the manufactured home is registered in the Manufactured Homes Registry, and a transport permit has been obtained from the registrar. Explanation. Under the Manufactured Home Act, moving a manufactured home requires it to be registered in the Manufactured Homes Registry. Additionally, a transport permit must be obtained from the registrar to ensure proper legal documentation and approval for the move. A is wrong because registration in the Land Title Office is not required for moving a manufactured home. C is incorrect as security interests in the Personal Property Registry are not the primary condition for moving the home. D is not enough on its own. Ownership alone doesn't meet the requirements without proper registration and permits. Question 20. Which of the following could appear as a charge on a certificate of title? The correct answer is B. An easement in favor of a local telecommunications company. Explanation. B is correct because easements can be registered as charges on a certificate of title. They are typically shown as a legal right to use part of the property for a specific purpose, such as for a telecommunications company to run cables or equipment. A refers to a trust, which is typically not registered directly on the title but noted separately. C indicates the property is held by an executor, which is more about the legal status of the title, not a charge. D refers to a procedural note regarding the duplicate certificate, which is not a charge on the title itself. Question 21. Which of the following statements is true under the Torrens system in British Columbia? The correct answer is C. A void deed has no legal effect and is not capable of transferring any title in the land from the vendor to the purchaser. Explanation. A void deed has no legal effect, meaning it doesn't transfer ownership. Other options are incorrect because A. A void deed can't guarantee recovery of title. B. Indefeasibility protects both fee simple owners and charge holders. D. The principle of indefeasibility doesn't relate to giving what one doesn't have. Question 22. A clerk in the Land Title Office mistakenly registered a fee simple transfer on the wrong title, with the result that Lot 5, owned by Michael, was transferred to Scott. Scott discovered this error, and instead of correcting the error, he sold the property to another person who was unaware of the clerical error and of Scott's dishonest conduct. Michael discovered the error after the buyer had registered the transfer from Scott. He wants his land restored to him and the register corrected. You correctly advise Michael that the correct answer is B. The person who bought the property, bona fide and for value, from Scott is protected by the British Columbia land title system. As a result, Michael cannot have his property restored to him. Explanation. Under the Torrens system, a bona fide purchaser for value, who bought from Scott, is protected, and Michael cannot recover the property from the buyer due to the principle of indefeasibility. Option A is incorrect because the error doesn't automatically mean the title will be corrected. Option C is incorrect because Michael's failure to register a lien doesn't impact the buyer's rights under the Torrens system. Option D is incorrect because the transfer isn't necessarily void. It's a mistake, not fraud by Scott. Question 23. Earl is the registered fee simple owner of Blackacre. Duke forges and registers a transfer of Blackacre to himself in fee simple. Duke then borrows $50,000 from Royalty Trust Co. The loan is secured against Blackacre by way of a mortgage. Which of the following statements is true? The correct answer is C. Because of the forgery, Earl can recover Blackacre free of Royalty's mortgage. Explanation. Since Duke forged the transfer, his ownership is invalid under the Torrens system. Earl, as the rightful owner, can recover Blackacre, and the forgery means the mortgage registered by Royalty Trust Co. has no effect on the property. Option A is incorrect because Royalty Trust Co. cannot rely on Duke's forged title. Option B is incorrect because Earl can recover the property free of the mortgage due to the forgery. Option D is incorrect because Royalty Trust Co. would need to make a claim against the assurance fund, but that would be based on a valid transaction, not a forged title. Question 24. Which of the following statements regarding manufactured home registration is false? D is false statement here. If an owner discovers that their manufactured home is not registered, they must register the home within 30 days of that discovery. Explanation. There is no strict 30-day requirement for registering a manufactured home if the owner discovers it is not registered. Registration should be done promptly, but the 30-day rule doesn't apply here. Option A is true because the transfer of a manufactured home is not effective unless both the home and the transfer are registered. Option B is true because ownership of a manufactured home must be registered before it can be imported into British Columbia. Option C is true because the registrar will assign a number and issue decals after the initial registration of the home. Question 25. The abolition of the doctrine of notice by the Land Title Act is subject to the exception of. The correct answer is B, fraud. Explanation. The abolition of the doctrine of notice under the Land Title Act means that a person's interest in land is generally protected by the land title system, regardless of whether they had notice of prior unregistered interests. However, fraud is an exception. If a person acquires property through fraudulent means, they are not protected by the principle of indefeasibility under the Land Title Act. Question 26. Which of the following statements about the principles that apply to all strata developments in British Columbia is true? The correct statement is A. The Strata Property Act generally does not apply on First Nation reserve land, subject to some exceptions. B. The Civil Resolution Tribunal does not conduct random audits. It resolves disputes between strata owners and corporations. Residential strata developments with 3 or fewer units still have some requirements under the Strata Property Act, including holding meetings. D. Commercial and industrial strata developments follow the same general compliance requirements as residential ones under the Strata Property Act. Question 27. Which of the following best describes the principle of indefeasibility in British Columbia? The correct answer is C. Any registered owner who acquires a fee simple estate in good faith and for valuable consideration is protected by our land title system. A. This describes the opposite of indefeasibility. A break in title doesn't automatically invalidate subsequent transactions in the Torrens system. B. This is incorrect because indefeasibility protects purchasers who act in good faith and for value, even if the seller had no right to the property. D. This is not entirely correct. The principle of indefeasibility is based on registration, but ownership is not automatically conclusive just because the previous owner named someone as the new owner. The key factor is the registration of the title. Question 28. The principle that the person named on a particular certificate of title is entitled to a fee simple interest in that property, free from any condition or encumbrance that is not shown on title, is known as the correct answer is D, indefeasibility principle. Explanation. The indefeasibility principle ensures that the registered owner of a property holds the fee simple interest free from any unregistered claims or encumbrances, as long as those claims are not noted on the certificate of title.
Question 29. Which of the following appears in the description of land section of a land title search in British Columbia? The correct answer is B, parcel identifier or PID. Explanation. The description of land section typically includes the parcel identifier, PID, which is a unique identifier for the property in the land title system. The other options, civic address, dimensions, and geodetic coordinates, are not usually included in this specific section. Question 30. Which of the following is not a component of the British Columbia land title registration system? The correct answer is B, the doctrine of the void deed. Explanation. The British Columbia land title registration system is based on principles like the assurance principle, abolition of the doctrine of notice, and indefeasibility of registered fee simple titles. These principles ensure that title to land, once registered, is protected. The doctrine of the void deed is not a component of the BC system. In the Torrens system, used in BC, a deed that is void does not transfer any interest, but it is not a central principle of the land title registration system itself.
Question 31. There are 3 common types of void deeds. Which one is considered not to be a void deed? The correct answer is A, an unregistered deed. Explanation. Unregistered deeds are not considered void deeds under the Torrens system. While registration is necessary to give notice and effect to a deed, an unregistered deed does not automatically void the transaction. It simply lacks the effect of registration. Forged deeds, deeds given for illegal consideration, and deeds signed under circumstances where the party can plead non est factum, meaning the party was not aware of what they were signing, are considered void deeds because they lack legal validity.